Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe to iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbird LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Troutman Pepperell Hamilton Sanders LLP, with today's topic.
Welcome back to the Digital Planning Podcast. Ross, Justin, and I are thrilled to welcome Sharon Hartung back to our show. Sharon is a professional engineer, a retired captain from the Royal Canadian Air Force, a former IBM executive, and now the founder and CEO of Your Digital Undertaker, a company that specializes in the consulting and technical management aspects of digital assets in estate planning. Sharon was on the Digital Planning Podcast in 2019, episodes 13 and 14, where she shared how she transitioned her career from the military to IBM and now into the estate world. At the time, Sharon had just published the book, Your Digital Undertaker, exploring death in the digital age. And I think she has some more books in the works, which I look forward to hearing about. Welcome back, Sharon.
Thanks so much, Jen, for the lovely introduction, and thanks to all of you. I can't believe it's been a year already in terms of what's happened, but I really appreciate being back again.
Sharon, given the year we've had, we thought we could hear from you on a few fronts. First, I'd love to get your perspective on the digital assets global landscape overall, as you may call it, the state of the nation. I know you've been talking to a lot of other practitioners globally, and you've been participating in a lot of events and webinars, and you've written a lot of articles. You've been keeping yourself very busy, as well as participating on the Society of Trust and Estate Practitioners, also known as STEP's Digital Assets Special Interest Group. Do you want to tell us a little bit about some of those activities?
Absolutely. Thanks, Jen. Great question to get us kicked off. Where does one start? The pandemic has accelerated the technology conversation. I think we can agree. And we're talking all sectors, all industries, not just the financial and estate industries. We've relied on technology now to enable our basic processes at home, from ordering groceries, communicating with our loved ones, accessing healthcare, and working, never mind being entertained. The true ramifications, I think, will unfold in a number of years from now. But what I can say about the estate industry is buckle your seatbelts. We're in for a digital transformation, and it's likely going to be quite a roller coaster as things unfold and evolve. The traditional estate planning worlds as we know it will transform. I know, Ross, you've been involved in written articles on electronic wills for the ABA. You've had recently Kimberly Martin talking about her paper, Dawn of the New Era, Electronic Wills. And if I was just to take that one example, prior to the pandemic, electronic wills was not a mainstream conversation. When I did client speaking engagement, I get the occasional person asking, if I can take a picture of a check and deposit it, why are wills only in paper format? Now, prior to the pandemic, not a mainstream conversation. Certainly the legal community has been working on this for years with proposed model legislation or uniform legislation. And there are some jurisdictions globally that have adopted it. And I think Kimberly Martin's paper does a terrific job of kind of giving us a state of the nation on electronic wills. But it really wasn't a regular Twitter conversation until now. Legislated electronic wills will change everything. In my opinion, it will transform business process of the estate industry from the client front office to the firm back office to the estate court and legislative processes. Electronic wills will connect and integrate data and business processes. And if anything, those emergency orders that allowed remote will signings during the pandemic has opened the door.
Sharon, I completely agree. I think the majority of people don't even realize that they have digital assets, let alone the far-reaching implications that they're going to have in people's estates, especially if pre-planning for those digital assets does not take place. And right now, that's sort of the norm. And planning for digital assets is something that's more novel and exotic, but it really should become the norm for practitioners globally.
So Sharon, you've also taken a particular interest in QuadrigaCX case in terms of the lessons learned for estate planning. And I know that you and Jen just recently wrote an article that's in the STEP journal. and we're going to go into a deeper dive in it later, but can you give us just a quick background on it so our listeners know what's coming later today?
I've been following many of the media stories. I still recommend the Vanity Fair article written by Nathaniel Rich called Ponzi Schemes, Private Yachts, and Missing $250 Million in Cryptos, The Strange Tale of Quadriga. As I've kept up with the Quadriga story as it's unfolded in the media, I really started to wonder about some of the other digital assets, his email and his computers. And there's two significant investigations that have come out recently that really caused me to have a really good look. One is the May 2020 Ontario SEC report that came out. And then the other, obviously, was the appointment of Ernst & Young as the bankruptcy trustee through the bankruptcy court proceedings. So there's a lot of interesting information that's now available that allows us to look at this particular case.
Well, we will take a deeper dive a little bit later with you. But for now, let's go back to the digital asset landscape. And one of the things that you talked about with us last time you were on the episode of the Digital Planning Podcast is that you said that we were on the edge of what you called Estate 2K. Can you describe for us, for those listeners who didn't listen last time, can you just briefly describe what you mean by Estate 2K?
Yeah, so I've looked back in terms of some of the other significant transformations that we've had. Obviously, technology itself is an industrial transformation, but we all faced globally the issue of Y2K in the year 2000. And so I like that as a bit of analogy in terms of the massive transformation I think that's now going to hit not only the estate industry, but the death care industry. And I do believe, and I said this last year, that it's about the size of fintech when you also add in the complexity and the fact that we're on the cusp of the largest wealth transfer in history. The world is changing. The conversation about death literacy is changing. I mentioned last year about the death positive community. You know, they've been trying to increase the death literacy conversation. I gave examples like the Death Cafe. And I certainly think through the pandemic, the conversation has really, all of us have had to internalize, either facing personally or with our clients.
Yeah, I think the pandemic has really accelerated the conversation that people are having with regard to the death industry and what you call Estate 2K. So you have been speaking on the webinar circuit. You've been all over the place, and you've been talking a lot about digital asset topics. Can you tell us a little bit about what you've been learning and who you've met and what new ideas you've encountered on the circuit?
Absolutely. As you mentioned, when the pandemic hit, obviously everybody pivoted to the webinar. So this provided an exceptional opportunity for practitioners like myself to attend other conferences that we would have never had access to. But the topic of digital assets is finding a real home on the agenda of most estate conferences now, forums or even practitioner groups, in addition to the legal innovation events. Justin, you joined us with STEP on a STEP Crypto in Estate Planning panel back in October, which was tremendous. And you know, you've heard about the STEP recent global spotlight event, which I'm hoping we get to talk a little bit about too. Now, on the conference front, from a Canadian example perspective, ABT Insights, run by Andrew Bauer, held 2 estate virtual conferences, one in British Columbia and one in Ontario, and both had a special panel on digital assets specifically, with some tech entrepreneurs, legal perspective, myself from a tech management. Now, you may already know James Norris of the UK Digital Legacy Association. He's been running events on digital assets for years now. He didn't have an event in 2020, but I connected with James a couple of months ago, and he's planning one for 2021, which will be fantastic. Now, he's had the longest standing annual conference on the digital asset topic specifically. I've seen a general uptake in the digital asset topic. I've been invited not only by these conferences, but national financial, tax, insurance institutions, associations such as legal and seniors associations. The funeral industry has invited me to talk about this digital asset in our digital lives through this past year. Now, I'll also comment that on the legal innovation conference circuit globally is really taking off. The broader digitization of the estate industry is gaining traction. So I expect we'll not only see this conversation of digital assets in estate forums, but we're also going to see it in the legal innovation space. Now, the one area that I haven't quite seen take off yet in the digital asset space is the estate tax perspective. Certainly taxation of cryptocurrencies more broadly, yes, for the living, but I'm talking about the specific topic of taxation and accounting of digital assets on death. When we see this stream grow, we'll know that it's really hit the stride in the conversation on digital assets.
So jumping back for a moment on the uptick in articles and conferences about digital assets, I recall from when you joined us last year that you had mentioned you have Google alerts set for various keywords related to digital estates or digital assets or the administration of digital assets. And you mentioned back then that there weren't usually many alerts that you would get, even a year or 2 years ago. If you had to quantify it, what would you say the percentage in uptick from just your Google alerts has been with keywords on this topic?
A really good question, and it is a metric I follow personally. It's probably time to put it in the spreadsheet, but you're right. I use all the different words, digital assets, digital estates, digital estate planning, just to get a sense of how people are talking about the topic. I also use words like digital legacy, which is another word emerging in the space. A year ago, it was once a month, once a week that an article would appear. My Google Alerts pretty well has an email every day with 6 or 7 different links to various topics. The one other place I'm seeing it's a terminology issue, but digital estates is also referring to real estates in the pure property rights and property space too. So there's a bit of a couple of them that I always say, okay, these 5 are digital assets in the estate planning, and then these 2 are real estate related, because there's some overlapping in the terminology.
Sharon, you recently spoke at a STEP Spotlight event, and you spoke on the service provider perspective, and it's always unique in the digital asset space because we hear a lot about planning for your digital assets, but we don't necessarily hear the service provider perspective. What did you talk about from that perspective when you were recently speaking?
Lovely question. I was hoping you would ask because I was quite excited about our recent STEP Spotlight event. So maybe I'll give you a little context to the event so that the service provider panel that we did has some context. So the STEP organization has 7 special interest groups, and it holds an annual spotlight event. It generally is in person in London, UK. And like many organizations that had to deal with the pandemic reality, it went to a global virtual webinar, which was fantastic because now we had quite a significantly larger topics and groups being able to join together. So Jen and I were on our subcommittee for our STEP Digital Asset Spotlight event this year, and we had 3 sessions. And we really felt as a subcommittee that we needed to get a multidisciplinary view. So we approached it from the service provider tech perspective, the legislative and client perspective. So we had Kimberly Martin on electronic wills, and then we had a wonderful panel from a client perspective with people like Dr. Elaine Casket. The service provider tech perspective is an area that I'm quite passionate about, and the panel was called Digital Assets and Estate Planning, Understanding the Technology and Service Provider Viewpoint. I've been using the tagline, the technology is the new player at the estate planning table. So all the technology we use, whether it's a digital asset specifically, whether it's automation or use of technology in our business, or the future electronic wills and the process that unfolds from that, is all going to be provided by a technology or service provider in some way. So we really wanted to deep dive on that topic. And to do so, what I did is invited 4 guests. These are, pretty amazing people that have been in digital asset research and delivery. We had Dave Michaels from Queen Mary University in the UK. He shared a state of the nation on provider terms of service in terms of dealing with incapacity and or death from his Beyond the Cloud studies. We had him last year, so he was able to give us an update. Dr. Adina Harbanja is from the Aston University in the UK. She shared her work and perspectives on a concept she calls post-mortem privacy. And as we know, this is a complicated legal area because not only do clients have post-mortem wishes about their data, but those might conflict with service providers, the law, beneficiaries, and obviously the executors who need information to do their jobs. Fergal Brown from Facebook was there. He's a policy stakeholder manager at Facebook. He talked about how Facebook approaches stakeholder engagement and took us into the back room of how their teams are organized to deal with memorialization and legacy contacts. So it was pretty fascinating. And then our last speaker was Dr. Jed Brubaker from the Identity Lab, part of the Information Science Department at the University of Colorado in the USA. And what was most interesting is Jed's been researching the human centric design aspects of digital assets for about 10 years now, more than 10 years. And he was involved in the early days of the design of Facebook's legacy contacts. So getting his perspective was tremendous. Now, these different perspectives were tremendous for a couple of reasons, because we need to consider all these aspects: policy, law, human-centric design aspects, and the tech. And I really did launch this panel to try to start to have a regular conversation between STEP, our SIG members, and the estate industry and the tech industry at the same time.
I had the privilege of virtually attending the CLE, and it was fantastic. All the panelists were very, very good and knowledgeable, and you were a masterful moderator, Sharon.
Well, thanks, Jen. It was. I wish it had gone on for hours and hours, and I'm hoping that we can create some sort of a standing agenda so that next year we can check back in to see how things have changed on these kind of 4 dimensions. So we'll see how that goes.
Now, for people who may have missed the panel, do you know if there'll be any replays, or they'll have the opportunity to go through STEP and watch it at their leisure?
I'm not sure about the replays, but I can tell you I'm in the process of drafting an article to summarize some of the key findings from our wonderful panel. So we'll have something in that front for sure.
And speaking of writing, you've been doing a lot of writing over the last year, including a couple articles with Jen. Could you tell us about that?
Thanks. Yeah, Ross, I have used this past year to stay pretty focused on deep diving specific digital asset types, like kind of looking at email in detail, looking at social media in detail. And I wrote these articles really to try to tease out the technical management perspectives and the questions that advisors need to consider asking, just to introduce the topic to a client, or then know when to refer a client to a technical advisors. Now, most of my tech management deep dives have been published by LexisNexis Lawyers Daily, so you can find them there or find them on my website.
Excellent. So out of all of the writing and speaking you've done, you definitely have seemed to take a strong interest in the QuadrigaCX case. Just for people who are listening who don't really know much about it, QuadrigaCX was the largest cryptocurrency exchange in Canada, and all business operations came to an abrupt halt when the owner of the exchange, Gerald Cotton, died suddenly in India in December of 2018 without leaving any instructions to access the personal keys that are required to actually access the millions of funds that were account holder funds that were locked essentially in his computer. There's a lot of different theories and potential fraud surrounding the story, but what is your perspective on some of these issues, and what have you found in your research?
Okay, as I mentioned earlier, I too have been following this media story, and there's a couple of significant sort of investigations that unfolded, and I knew when the May 2020 Ontario SEC report came out, I knew that LexisNexis Daily would be interested in my perspective from a tech management point of view. So I rolled up my sleeves and started reviewing all the court documents. And as you know, Jen, you and I have been working on several files and STEP projects. As I was starting to go through reading and researching, I started to share with you some of the, I call them mundane aspects, but significant in the estate administration process, like his email, his computers, the fact that there's an intertwined personal life and his business life. And to me, they started to really reflect, potentially what any average estate administrator would face. And more importantly, for myself as a practitioner in estate planning, I've been giving people advice around things like email, helping them recognize that terms of service play in, that they should use Google's inactive account manager, for an example. So I was really curious on what would unfold in this particular case.
Sharon, following the framework that we developed to look at the technical and digital assets in the case that was in our recent Step Journal article, let's begin with really looking at the inventory and how that's extremely important and can be the key to really uncovering digital assets in the state administration. What did you find, and what's the planning application that's best suited for this as it relates to what you've learned in Quadriga?
Yeah, that's a great place to start with the inventory, but probably what I should point out is where did I get all the information, if anybody's interested. The Quadriga company was granted creditor protection with Ernst & Young, as I mentioned earlier, and they were appointed as the bankruptcy trustee. So the monitor prepared and filed a number of documents with the courts, and this is where I've gained most of the information. So there's inside the monitor's report, there's a section called Recovery Efforts on Devices and Accessible Information, where I am referring to most of this. Now, if we turn ourselves back to the inventory, certainly of significance for any estate administration, the first thing you want to do is find everything and get it into an inventory. So from a technology perspective or a digital asset perspective, that would mean looking for hardware devices, because that's likely the first place, either as a conduit to digital assets or they'll actually be located. So that's where you'll find someone's photos or manuscripts or other information. Gaining access to encrypted devices, as we've come to know, is very problematic and likely expensive. Even if these devices can be lawfully accessed by the fiduciary, technical access may not be possible if someone hasn't left information on how to actually get into those physical devices. And as you and I have discussed, Jen, many jurisdictions have implemented laws governing fiduciary ability to use the user's information to get in, but it's not uniform. Most jurisdictions have digital asset laws that allow the fiduciary to enter a computer or device, that hardware thing, but we know it's a lot more complicated on the digital asset side. And the trend, what I'm finding now as well, is for digital storage is the cloud-based services, such that you may get into the hard drive, but it may only be a conduit to storage services that are controlled by those service providers' terms of service. So what's tangible and accessible under fiduciary access laws might only result in being the conduit, so that might be not very helpful. Managing, I think, beneficiaries' expectation is going to be massively key in estate administration, because if there's no pre-planning and there's no digital asset and digital devices inventory list and no pre-plans were made for significant digital assets, they're going to be really difficult to get into. And, if it's encrypted, there's a whole ROI question, return of investment question that's going to have to be made by the fiduciary in terms of how much money they're going to spend trying to get into it. And as you and I commented in the article, I think a lot of people think accessing a hardware device or an online storage it's similar to using a bolt cutter on a storage locker, but it's not. It's a completely different space.
We've spoken a lot on the podcast about securing digital assets and the duties of executors to secure digital assets, or just individuals who own them, how they should keep their digital assets in a safe and secure place. What did you find, and what are the estate planning implications in this test case?
One of the most interesting things in that space that I found in this particular case was the Quadriga system or solution itself was hosted on Amazon Web Services. And the bankruptcy trustee had challenges getting access because there was inconsistency in billing names. So, simply said, if you looked at the court documents or what were submitted, is the invoice for Amazon Web Services and the Quadriga system were in someone else's name. So in 2019, or prior to 2019, they were in Gerald Cotton's personal name, and then at some point they switched to someone else's name. So you can appreciate as an estate administration fiduciary. If you want to get access to anything, and you have all the proper court documentation, and you approach a company to gain access, the name is significant in that case. So rightly so, Amazon Web Services would have said to the bankruptcy trustee, well, you can't have access because the individual's name is not on the account. And so they went back and got a court order and then went back and got access. What was significant in their need for access, as I understand, is obviously they would need to know the list of clients the list of clients' names that are on the platform and how much they were technically owed. So this is significant information in terms of the bankruptcy case. But what learnings that we can take from an estate planning and estate administration perspective, if you have a significant digital asset, whether that's a web domain, whether you have a Shopify account or an Amazon account, or even if you're an author or artist and have information or content that's located on somewhere, what's significant is to make sure that the account information is up to date so that your fiduciary can go and reach out to that particular company or service provider with the court documentation with your proper name and get access if they need to, if the terms of service allow. So that was a really interesting finding in the sense of the inconsistencies in the billing names affected the estate administration.
So what's interesting to me is the focus here on the identity of the person or entity that was getting the invoice as opposed to the identity of the person or entity that actually created the digital asset, right? And oftentimes that might be different. And just because one person or entity is receiving the invoice doesn't mean that that is the same person or entity who is entitled to the asset. Did you see any discussion or distinction made in any of the documents that you looked at?
No, and again, I'm looking at it from a practical project management perspective, as a fiduciary would. The first thing a fiduciary would do is approach these companies, and the first place the company would look is the billing information or the account holder ownership information, which I think in this case was the both. It can be different, so some platforms you can specify different things, but the fact that there was a discrepancy at the outset is probably what was required to go back to the courts and get a court order, and you can imagine that there was probably a process there to determine ownership, and therefore that's why the court order was issued.
And that can also be very expensive, especially for the average estate.
Right. If I look at most domain hosts, because most people will recognize that if they have a website of any kind, you're going to need a domain hoster of some time. Most systems or platforms have several different sections that you fill out as an account profile. So you fill out the names of the administrators, you fill out the names of the owners, you fill out billing information. So there are potentially even more complicated situations, Justin, when you think of there could be 3 or 4 different names. What I typically recommend to clients from a technical management planning perspective is to make sure that the names for each of those kinds of categories is up to date, and then wrap their business continuity planning and their legal instruments around that to explain why there may be different names for different purposes as part of the business continuity plan, and then the associated estate legal instruments to support that. But when there's inconsistencies, it's, as you point out, it's a big challenge.
Absolutely. And, I'll add that it's important to include all of that type of information on the inventory, and especially with website domains, any type of expiration date that should be known. Did you see anything else interesting about the website for Quadriga in your research?
Yeah, I mean, the first thing that we all do is go to the website called Who Is, and you can punch in a web address there, and it will tell you who owns it, and oftentimes the information is protected for privacy. But one thing I did look at is I looked at the QuadrigaCX.com website, and initially it redirected to the monitor, and now it seems to be open. It looks like someone has allowed the domain to expire, but it hasn't yet been released on the public domain. What's curious when you go to whois.com and looked at QuadrigaCX.com, the information about who owned it was redacted. So what's not explained in the court documents is how they were able to redirect to the monitor's website, but that either meant that someone had administrator access to the domain, or that the domain company responded to a court order. I can only conjecture at this point because there was no information. But it's interesting. Web domains can have value, so it's pretty important that information about them is left in some sort of business continuity planning from a small business perspective, or even for an individual, and that the fiduciary is made aware, because they will need to renew that web domain, which is typically done on an annual basis, although some domain providers allow you to buy out in advance in the future. But as of September, as far as I can tell from whois.com, that domain QuadrigaCX.com hasn't been kept up to date.
So one of the things that is interesting to me with digital assets and cryptocurrencies is the valuation of these currencies and these assets, and what mechanisms are used to value. And did you find anything interesting in your research about how they valued the asset in this situation?
No, unfortunately, the court documents didn't provide any of that, but that is an emerging area for sure. There are some articles I've started to see from the tax and accounting community in terms of trying to provide a framework for that. The only analogy that I can give you from a project management point of view, it's from a tracking and valuation perspective, is not unlike stock in the sense of, it has a value at a certain period of time, and you've got to keep records over the life cycle of it. And as we know with cryptocurrencies, you can use fiat cash to buy into basically Bitcoin and some of the other more known cryptos, but then after that you have to convert from Bitcoin into some of the other cryptos, which from a tax perspective and a paper trail perspective means there's a lot of paperwork that people need to keep up to date as they get into that space. So like I said earlier, this is an emerging area, is the tax, and it'll be interesting to get some tax expert to start to comment on this as people deal with these kinds of assets in a state administration perspective.
And also, when there are keys that are involved in unlocking the digital asset or the cryptocurrency, is the value of the underlying asset tied in any way to the key? And does the key itself have any value? And I don't know that there's been much, if anything, that I have seen written on it. I don't know about you, Sharon. Have you seen anything on that distinction?
No, that's definitely an emerging area.
I know that there are a few valuation firms that are beginning to tout that they have expertise in valuing digital assets, but I think most of that is really just tied to cryptocurrencies and not some of the other assets that are growing.
Yeah, from a project management point of view, we know it's going to be a labor-intensive process, right? Someone is going to have to track this stuff, and the onus is really going to be on the testator or will maker to provide all this tax-based cost information in some way that the fiduciary can use it. And we know from physical property and physical rights that if that valuation or tax information is not left in some form for the fiduciary, unfortunately, then the rules in a jurisdiction start, dictate what the tax base cost might be. And unfortunately, that tends to be higher than someone may truly have bought it or valuated it.
Or no basis at all.
Or no basis.
So Sharon, back to the Quadriga case, what do you think happens next?
Well, I think there are some investigations left to unfold, as I understand from listening to Nathaniel Rich. The FBI is investigating, the RCMP is still investigating. He must have had sources that told him that. So I think we're going to continue to see other things unfold from this. And hopefully those investigative resources are able to follow some of the money trail that they weren't able to determine. Because unfortunately with this story is obviously there's a lot of clients who are going to be left not receiving a whole lot from what was eventually found.
So Sharon, you dove pretty deep into this case. What reflections do you have now that you've taken a look at and analyzed the technology in this particular situation?
Yeah, and in the context that I come from, I looked at the hardware, the Google Gmail, the various email accounts, etc. The biggest reflection for me was a validation, quite frankly, in terms of some of the guidance I've been giving people in terms of we must pre-plan our digital assets. This is a fundamental tenet difference between physical property rights and real estate and physical property. Even if we do see options emerging from service providers, they're going to be different. The fiduciary is going to know which ones you select. If I even take something like Google's inactive account manager and Facebook's legacy contact, if you use those pre-planning tools and if you pick a name other than your fiduciary, I know that the STEP inventory for digital asset and digital devices recommends during planning, if you use these pre-planning tools, that you need to let your fiduciary know. I think there's a lot more project planning that's going to be required as part of estate planning in order for your fiduciary to be successful, because they're going to be taking on a digital project, whether they want to or not, either because someone owns digital assets, they rely on digital assets to house information like our email, or our physical property rights have become intertwined with our digital landscape. So today's fiduciary, as you know, I've been saying, is a digital fiduciary, and the only way to handle a digital project is to plan in advance.
I couldn't agree more. Well said. Any final thoughts on just estate planning and the industry in general with digital assets?
Absolutely. I'd say post-pandemic, I go as far to say if your estate group, firm, or profession is not talking about digital assets and the digital transformation of the estate industry, you're going to soon be behind. I wouldn't have said that a year ago. The pandemic has accelerated us collectively in a way that we need to not only be aware, but we need to start thinking about the policies and the practices, tools and teams that we're going to need to support our own businesses and then the broader landscape. I continue to applaud the three of you and your organizations for supporting this podcast. I think it's in place at a critical time where we need to hear about what we're learning in the space and share that learning, because we have a lot more questions that are unanswered than we have answers. But, this kind of forum allows us to share information so that we can grow that. Raising this awareness of the topic is going to be pretty critical and important. And you will appreciate, I'm a big fan of STEP Global's organization, a big fan of the Digital Asset SIG, because there's some wonderful people that are sharing information there. Encourage people to join STEP. Join the Digital Asset SIG. It is no charge. You do not need to be a STEP member. You can join. And then the one other thing that STEP has done recently is there's a new membership category called the Friends of STEP. It's for tech companies, entrepreneurs, service providers to get connected with STEP Global. There's a annual fee and a short application, but there's another channel to join the conversation in the STEP organization.
Well, thank you so much for your kind words and also for being a pioneer and advocate for raising awareness and education about digital assets and certainly being a global leader in the framework in how tech and the estate industry need to partner together. So how can our audience members contact you, Sharon?
Well, thank you again to the three of you, Justin, Ross, and Jen, for inviting me. I always enjoy these conversations. Certainly follow me on Twitter at Undertaker Tech. There's a very active digital asset community on Twitter, so check it out. That's where I've met a lot of wonderful people. Certainly connect with me on LinkedIn. I am on Facebook and Instagram at Your Digital Undertaker, and my website, yourdigitalundertaker.ca or .com.
Well, Sharon, thank you so much again for coming on to our podcast and speaking to us today about digital assets and the QuadrigaCX case. We hope that you have all enjoyed this episode with Sharon, and we will see you again next time.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review on iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.
This podcast is not intended, nor should be relied upon as legal advice, nor is it creating any attorney-client relationship with a listener and the hosts or guests. The information provided is only for educational and informational purposes, and the information provided will likely change.